Okay. Greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. We're coming again tonight with some more information in support of my video last night to Andrea Dreyer. Again, hoping she'll do some review on some of these, some of the information that I've researched as it relates to correcting the record. And what we're going to start out with tonight is that Social Security number and the comments relative to last night's video as it relates to the individual. And so first what I'm going to pull is 20 CFR, and I stated it last night as 402.103. And in fact, and I did make a comment in the details or the comments in that video last night that I corrected it. It is, in fact, 20 CFR, as we see here, 422.103. And in that, this is where we find where it says, under Social Security numbers, General, the Social Security Administration maintains a record of the earnings reported for each individual assigned a Social Security number. Now, the individual is the name, and that name is assigned a Social Security number. And the individual's name and Social Security number identify the record. It does not identify the individual. It does not identify yourself. It is the individual and the number, the name and the number. Individual name and Social Security number identify the record. The individual is the one that is assigned a Social Security number. And you, at the age of 18, when you apply through an SS5 application, are granted the use or authorized the use of a Social Security card, property of the Social Security Administration. And on that card, or in that card, it has the name, the individual's name and the numbers. And there are two numbers. There's one on the front and one on the back. That Social Security card is known as a card, a credit device used to purchase, or used to obtain money, property, labor, or services. By definition. The next one, as it relates to that individual, is 5 USC 552A, records maintained on individuals. The term individual means a citizen of the United States or an alien lawfully admitted for permanent residence. I am not a lawful alien, as I am native to this world. I am in this world, but not of this world, but born in this world through my nativity. The next one we're going to discuss is the legal fiction. Before I go any further, I'd like to ask everybody, please hit that like, share, and subscribe button. Greetings, everybody. Got JZ Bay, The Bex Factor, Russ Combs, Kara, Jen, Hard Hat. Greetings, everybody. Anybody else that I missed, my apologies. The StreamYard link is there for anybody who wants to join the panel tonight. I do have a bit of material that we're going to go over, but I'm going to skim most of it because it's just a matter of plain writing and language that is easy to comprehend and is just basically showing and connecting dots. And let's see here, the next one I've got is 48 CFR. Under the Code of Federal Code of Federal Regulations, Title 48 is for Federal Acquisitions Regulation System. And under 48 CFR 52.212-5, it says contract terms and conditions required to implement statutes or executive orders hyphen commercial products and commercial services. Okay, so the Social Security card is a form of a credit card. It is any card or plate or something used to obtain money, property, labor, or services. Okay. Even though you thought it was for your benefit, it has a benefit. But in using that, it's been converted to a contract instead of accepting you as the creditor or benefactor to the beneficiary record. In order for them to implement any executive orders or statutes, they have to have contract terms and conditions required to implement. So what we have is a Code of Federal Regulations that shows contracts between executive orders and statutes that implement them between the federal government and the United States and the states of Iowa, state of Illinois, state of Arizona, blah, blah, blah. United States is a commercial corporation. The state of Iowa is a franchise of that corporation. The federal government at 5 CFR 575.102 says federal government means all entities of the government of the United States, including the United States Postal Service and the Postal Regulatory Commission. The next one we're going to talk about is 31 CFR 156.1, purpose. Now this one here has a bunch of executive orders and some codes here that we're going to skim over again real quick. But again, I've already done a video on this specific code, laying out all of these executive orders. It's back in my YouTube channel. I don't know how far ago, and I can't remember what I titled it, but I can always pull it up again sometime. You can go through and look at them. And that's the purpose of doing all these videos. This stuff is so comprehensive that you can't do it in one little video. I've been doing this for 7 years to figure this out. This part updates policies and responsibilities for the Department of Defense Personnel Security Program, consistent with Executive Order 12968. And in order to implement, there must be contract terms and conditions. It's a requirement to implement them. Same with Executive Order 10450 as amended, Executive Order 10865 as amended, Executive Order 13526 as amended, Executive 13526, Executive Order 12829 as amended, Executive Order 13467, 13488, 1233, 333 as amended, 5 USC 301 and 7532. Blah, 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 Public Law 1110 or 110-80 as amended, 15 USC 278 G-3. That's part of the Trade and Commerce, which is actually trust law. 15 USC 1 and 15 USC 3, speaking on antitrust. 40 U.S.C. 11331, 10 U.S.C. 1564, which is military. This is all in relation to the Trading with the Enemy Act. 32 CFR Parts 147, 154 through 156, 50 U.S.C. 3343, again, national defense, again with the Trading with the Enemy Act, specifically laid out in 50 U.S.C. 4035, excuse me. I'll have to look that up again just to make sure. I believe it's 4035. Let's do a double check. 4305. 5 U.S.C. 4305 is the directive for full acquittance and discharge at Section B2 in the interest of the United States, for the account of the United States, and for the person making the same, myself, the benefactor / principal, so that no person shall be held liable in any court. And under this 5 U.S.C. 301, we have departmental regulations. The head of an executive department or military department may prescribe regulations for the government, blah, blah, blah. And this is the short codified part in the U.S. Code. If you go to the U.S. government site for 5 U.S.C. 301, get this blown up and go over here. Under 301 departmental regulations, you'll see it's got a bit more than just this top part here. When we go down here, it says the words executive department are substituted for department, as the definition of department applicable to this section is coextensive with the definition of executive department in section 101. The words not inconsistent with law are omitted as da 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 da. The words or military department da 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 da. National Security Act of 1947, the provisions of Title IV of the revised statutes as now or hereafter amended shall be applicable to the Department of Defense, is omitted from this title, but is not repealed, telling us that this is applicable to the Department of Defense. In this, we talk about the plain writing in government documents. The purpose of this act is to improve the effectiveness and accountability of federal agents to the public by promoting clear government communication that the public can understand and use. The term covered document means any document that is necessary for obtaining any federal government benefit or service or filing taxes. Provides information about any federal government benefit or service, explains to the public how to comply with a requirement the federal government administers or enforces, includes whether in paper or electronic form, a letter, publication, form, notice, or instruction, and does not include a regulation. Plain writing. The term plain writing means writing that is clear, concise, well organized, and follows other best practices appropriate to the subject or field and intended audience. The next one we're going to talk about minimum standards for birth certificates. Definition. Again, I remind you, folks, this is applicable to the Department of Defense. It does not state that it is applicable to anything else. So everybody that is applying it through the federal government, which means all entities of the government of the United States, means it's a corporate activity. Definition in this section, enacting this note. It is a promise if it is a note. It is a draft if it is an order. And repealing provisions set out as a note below. The term birth certificate means a certificate of birth for an individual, regardless of where born, who is the citizen or national of the United States at birth, whose birth is registered in the United States, whose birth is registered in the United States. While it is clear the United States has no birth registration. I'll pull it up. ABA, AmericanBar.org. This is the American Bar Association, a decentralized system. In the United States, there is no national federal birth registry. End of story, folks. Under 5 U.S.C. 301, there creates an impossibility of being born in the United States under a birth registry. There is no such record. I'll be clear. This is in agreement with the American Bar Association. The next one we're going to discuss is in regards to the payment that I've been speaking about, that of these government officials and corporations and people want and demand. And it's known as payment redemption. It means the same thing. Leviticus 25, verse 25. If your brother be waxen and poor, and hath sold off his possessions, and one of his kin come back to buy back what he has sold off. That is what redemption means, is to buy back. Somebody else bought it, meaning your brother sold it. And in order to make payment, you are buying it back. Very plain English, folks. The next one is the Federal Registry, if I can get it to pull up. Please bear with me. There we go. Okay, let's try this again. There we go. Okay. This is Friday, March 4th, 1994. Federal Register. Second class newspaper. Postage and fees paid. Remember, we were talking about the franking privilege. We're going to talk about that in another video. I'm going to do a video on the Universal Postal Union What is it? Let me pull that up real quick. Act 3, or Act in 3 volumes, the Manual of the Convention, another online PDF, Universal Postal Union Convention Manual. And when we look up here and do our find search to find something, we put franking in there, and it comes up, like I stated in the video the other day, 57 times. So there's 57 places it's going to talk about franking impressions in here as it relates to prepaid postage. So back to the Federal Register. This is from the United States Government Printing Office. Briefings on how to use the Federal Register. Federal Register provides a uniform system for making available to the public regulations and legal notices issued by federal agencies. These include presidential proclamations and executive orders, and federal agency documents having general applicability and legal effect. Documents required to be published by act of Congress and other federal agency documents of public interest. Documents are on file for public inspection in the Office of the Federal Register. Again, there is no birth registration in the United States. There is no federal registry of births in the United States. Therefore, again, the states ceded their jurisdiction to the United States. The United States is the debtor as a corporate debtor and is located in Washington, D.C. Washington, D.C. is the physical boundary of 10 square miles that has no sovereignty. And the United States is located therein, and therefore it has no sovereignty either. It is all a corporate entity for tax purposes and personal identification, so that things can be kept track of, records and files can be maintained, and eventually entered into the National Archives for historical value. The day before they are published, unless earlier filing is requested by the issuing agency. The issuing agent in this case is the clerk of courts at the local Black Hawk County. And that document is part of a statistical jurisdiction that is obtained by the state through the enumeration at birth that creates the state's individual vital statistics jurisdiction for each individual, which is exclusive to each individual and carries an equal station as the exclusive jurisdiction of the federal government. The next one, we're going to start talking about the Sunshine Act when it comes to freedom of information. Because the Freedom of Information Act, as it relates to the Sunshine Act, is the Physician Payment Sunshine Act. See, the Sunshine Act is what audit them and other First Amendment auditors use on those Freedom of Information Act requests. It's relative to the Physician Payment Sunshine Act. Physician Financial Transparency Reports. Like I said, that enumeration at birth doesn't hold the qualified financial statement of intent that is required to be handwritten by mom in order to transfer an asset to be used for a liability purpose to begin with. The Physician Payment Sunshine Act is designed to increase transparency around the financial relationships between physicians, teaching hospitals, and manufacturers of drugs, medical devices, and biologics. The Centers for Medicare and Medicaid Services fulfills the law's mandate via the Open Payments Program. This is the entrance through the enumeration at birth of the human or Health and Human Services for Medicare and Medicaid services, and that is conducted for Social Security Administration. But the Centers for Medicare and Medicaid Services is not the Social Security Administration. That is another another system that fulfills law's mandate via the Open Payments Program. They aren't just maintaining records, they're fulfilling the law of payments. This is why I said that card is an authorization for you to perform contracts or for payments. Sunshine laws under Cornell Law School, LIWEX. Sunshine laws are regulations requiring public disclosure of government agency meetings as it relates to the resident. No person shall reside within the zone except federal, state, or municipal officers or agents whose resident presence is deemed necessary by the board. The board consisting of the Secretary of Commerce as the head or as the executive chair and the Secretary of Treasury. Now, if I am not qualified to have the minutes of that meeting that deemed me necessary as a resident, then I must not be the resident. Sunshine laws, if there is such a record. That's what I'm saying. I don't think there is any such record. Sunshine laws require specific business and government agencies to maintain transparency and disclose their activities to the public without saying private, specific businesses and government agencies, meaning private businesses and government agencies, to maintain transparency and disclose their activities to the public. The language expresses it. They're not public, so they must be private because they're supposed to express them to the public. The primary objective, at least that's my interpretation, the primary objective of these laws is to prevent fraud, corruption, inequality, and to maintain high ethical standards within such businesses and agencies. I'm not a business. I'm not an agent or an agency. Take a break real quick to remind everybody, please hit that like, share, and subscribe button. Welcome to MW, Sheila Miller, Runchella. Greetings, everybody else. Of course, the panel link is down there. If anybody wants to share some love, let me grab that and drop it again in case it's gone by. Come up and speak on any matters. My apologies for the misstatement there. And then the next one, and you know what? I forgot to move the panel. So here's that Sunshine Laws. Anybody wants to get a screenshot of it, you can just look it up on Cornell Law School, LIWEX. LIWEX, Sunshine Laws, and it should show up. But the objective is to prevent fraud, corruption, inequality, and to maintain high ethical standards within such businesses and agencies. The next one is the government in the Sunshine Act basics. the Information Interchange Bulletin number 17 from the Administrative Conference of the United States. It's an independent federal agency that develops recommendations to improve administrative process and procedure. ACUS also arranges for the interchange of useful information to carry out its mission. ACUS information interchange bulletins are intended to help agencies and the public understand the administrative process. They should not be relied upon as legal documents. The government in the Sunshine Act, better known simply as the Sunshine Act, requires that meetings of certain federal agencies be open to public observation. So again, as I said yesterday, the resident determination is to be had by a federal government agency known as the Treasury, and therefore, the Secretary of Commerce. So it's the Department of Commerce at the federal level, and the Secretary of the Treasury at the federal level. These are the ones that carry the minutes of the meetings that are open to such Freedom of Information Acts. The states are hiding the interest for portions of the meetings, in my opinion, of course. Portions of the meetings that are covered by any of the Act's 10 enumerated exemptions. The Act also includes requirements for closing and publicizing meetings to which it applies, as well as keeping certain meeting-related records. Which agencies are subject to the Sunshine Act? The Act applies only to federal agencies headed by collegial bodies, boards, councils, and commissions. The Postal Regulatory Commission, the Postal Service Board of Contract Appeals, City Council, County Commission, Social Security Commission, Military Board of Commissions, Civilian Board of Commissions, I believe it's the Armed Forces Board of Commissions. See, it's all a matter of the documentation instrumented by a military fiat. It's the paperwork. A majority, again, in my opinion, a majority of whose members are presidentially appointed and Senate confirmed. And 2, any subdivision, the states themselves are subdivisions. They are political subdivisions of such an agency authorized to act on its behalf. Only about 50 federal agencies are subject to the Act, but all 50 states are, and all of those businesses and other government agencies are. What agency activities are covered by the Sunshine Act? The Act only applies to meetings, which defines as deliberations of a quorum of a covered agency's members that determine or result in a joint conduct or disposition of official agency business. I am not in the business of courting fictions. As I said earlier, a note is a promise. Notational voting. One of the reasons I mentioned the voter registration, I do not vote. There's a thing known as a parlay where you can cast your vote. Where we get our voting system from casting parlays. It's a piracy term, but most pirates cast their vote for themselves. I will let the record reflect that if I cast any vote, it will be for Jesus. Whereby any agency's members receive written materials, review them, and provide their votes in writing. where agency members receive, and as it relates to the personal jurisdiction, I am not required nor qualified to receive such written materials of posting of accounts through the Postal Service. I am not a service agent. I do not provide personal services. I have never knowingly, willingly, and intentionally leased my personal services. Nor have I ever been properly compensated, if that is what a presumption on that record would show, as invested as a firm in providing an obligor number and provide their votes in writing. It is not covered by the Act. Likewise, the Act does not apply to meetings of agency personnel other than members. Does the Sunshine Act require agencies to convene meetings to make certain decisions? No. Courts have repeatedly held that the Act does not require agencies to convene public meetings to conduct their business. So leave me out of your public meetings wherein I don't have to be there and you don't have to do that to conduct business. If agencies wish to conduct all their business by notational voting or some other approach, nothing in the Act prevents it. When can agencies close meetings? Agencies subject to the Act may close portions of meetings that are likely to disclose information properly classified in the interest of national security, relate solely to the agency's internal personnel rules, disclose matters specifically exempted from disclosure by statute. So specifically exempted from by disclosure by contracting. So you can contract to have certain things exempted, but they are already pre-existing. Disclosing such trade secrets that were already existent but specifically exempted. Disclose trade secrets or confidential business information because there's a contract at hand that allows you to perform business, and that business contract contains privity, meaning confidential information. Involve formally censoring someone or accusing someone of a crime. Involve formally censoring someone. The censoring of someone could only be not allowing someone to enter information into their records, because everybody has the freedom of the press. You can press it in public forums. Again, this is telling you that this agency has some privity and therefore it's operating privately. If they don't want you to enter information into their record or file things, they are not going to let you. This is why they say you are required to have an attorney handle that for you. You are not subject to their business procedures, their business, their internal personnel rules. Disclose personal information if disclosure would be clearly unwarranted invasion of personal privacy. Stay out of my life. That individual record does not belong to me. It is not me. You cannot summons me by that individual record. I have told you I am not qualified to receive service. I will keep clarifying this as many ways as I can. I am not a resident. I am not a United States citizen, as that is an impossibility, again, as I've stated and shown here tonight. Unless you can prove otherwise, your presumption fails. Disclose investigatory records in a way that would harm further proceedings. Disclose investigatory records in a way that would harm further proceedings. You can continue on with your proceedings with your members. I am not trying to stop that. I am not here to destroy your law. Again, I'm here to uphold the law. And again, my apologies. I am no good at this. But Administrative Conference of the United States is what I'm reading from. Government in the Sunshine Act Basics. Disclose information contained in or related to certain reports prepared by or for an agency that regulates or supervises financial institutions. Again, as it goes to the court record and the conversion of the last name to a firm name would be indicative, whether it be a law firm, an accounting firm, an investment firm, whatever firm, it would be such an investment type of financial institution. Disclose information that would likely lead to significant financial speculation. Significantly endanger a financial institution's stability, or significantly frustrate implementation of a proposed agency action. It cannot frustrate that which is supposed to be true and correct at the beginning by trying to correct that which is in error from the beginning. Again, contracts require privity. So by trying to contract with somebody in an open public forum and then issue a continuance as if though somehow that the one that walked into that court as a first-hand witness somehow magically became a defendant, that is an impossibility. Concern the agency's issuance of a subpoena, participation in certain judicial proceedings or arbitrations, or initiation, conduct, or disposition of certain agency adjudications. Again, in the bench warrant, you found no disposition records. There were no charges. There was no bond posted, and it says no bond posted, and no finances. And yet, Andrea, you posted to the adjudicated account of the Black Hawk County record and named a defendant. That defendant, Andrea Dreyer, according to the Administrative Office of the United States Courts, under Form A0430 is recognized material facts evidenced that the plaintiff is one of these categories. He is either the plaintiff, other, you can specify, government, or debtor. While at the same time, on the opposite side of this line, denoting some form of a T ledger, with certain information on this side of this ledger, and certain information on this side of the ledger. And we see we have a presiding judge, and we can name him chancellor, and he is no longer, or she, no longer a district judge, a bankruptcy judge, or a magistrate judge, as you pretend in these proceedings, the initiating stages, and we can specify other. Or actually, the presiding judge would be Andrea Dreyer, and we'll put it as we see it on your docket. So we get the correct military style, since you operate in that court with 2 flags with gold fringes. Admiralty. And then down here, we put chancellor. Type of proceeding is equity. Come on. You'll have to excuse me, folks. I really need a new laptop. Having to copy and paste the certain letters in here, I'm being slowed down. But of course, like I said, it's equity. And the plaintiff is the trustee. And those are the supplemental facts that I can put to the case, because as far as the case number goes, to help sustain the state's budget, it's no longer just the bench warrant. It's all 94 cases on the docket that need to be corrected. And that would be, of course, through a declassification of some sort. And as far as my research shows, that's Form 715 from the Department of Defense, declassification. And we can go over that at any point too. So the next one, as it relates to that bond that you posted, is the mailbox rule. The mailbox rule, also called the posting rule, because you posted a bond, refers to the default rule in contract law for determining when an offer was accepted. See, I don't know that any offer was made for you to post a bond, or how all that works. But I do know that the mailbox rule, also called the posting rule, refers to the default rule in contract law for determining when an offer was accepted. Under the mailbox rule, an offer is considered accepted the moment the offeree mails the letter. Rather than when the offerer receives the letter in the mail. That's because the United States Postal Service is the registered agent, and that is called service. Now, whether he fulfills his service is up to him. Now, if he sends it on to somebody else that you deem is an agent and it doesn't reach there, maybe who you think is an agent isn't an agent. Maybe that's why he couldn't be reached. Maybe that person has done his research and come to find out that all he has to do is retire the person. So I want everybody to pay attention. Because I have firsthand witness, in, on, and for the record, of Keith Little being a member of the American Association of Retired Persons. He is retired. They are an advocate for retired persons, and I will use them as much as I can or need to as an establishment of the record of my cognizance of retiring the person. And like I said, I've had no bank account for 7 years. I've had no job for 7 years. I've had no ID for 7 years. I've had no driver license for 7 years. I've had no fishing license, hunting license. I've had no minimum state contacts through political subdivisions or resident determinations. So let's get back to it. And real quick, I want to thank Nubs for showing up. How you doing, brother?
What's up, man? Hey, I put a question in the comments in the private chat there. That last document, I saw a lot of boxes. Does the rule of four corners apply to documents such as that?
When we look at the rule of four corners, you'll see how I played it out. I showed there was a line straight down the document that keeps the left side from the right side. Same thing with the square that goes around the plaintiff, debtor, other, and government. Those are all four like kinds, so you can pick one or the other.
Okay.
So that remains in that box. So it applies to like kindness.
The other reason that I came up, it was that question, and you had said I want to see a finished product a while back. So if I may interrupt for a moment.
And what's that again? Those are the growing boxes?
Cedar planter boxes. Yeah, cedar and redwood.
Awesome.
This is Shishugibon, which is it's redwood is what this particular type of wood is, but it's reclaimed redwood. And then this is the other one that I built.
Nice.
And I just gave it a shallow planter so you didn't have to fill that whole fucking 2 feet worth of dirt.
Yeah.
Keep it a little lighter on people's porches and stuff.
Yep. Awesome stuff, brother.
That's the only reason I came up is I wanted you to see that I was being accountable to my actions or to my words.
Awesome, brother. Awesome. I appreciate that.
Hey, man, great show today, and I'll get out of your hair. I'll be in the chat. Thanks much.
And real quick, guys, I want to remind everybody to hit that like, share, and subscribe button. Welcome, Russ Combs, Kara, Willie F., Forrest Jackson, Sheila Miller, everybody. Please hit that like, share, and subscribe. Get this stuff out there. And we're going to continue on with the rest of it here because it goes on to say the mailbox rule also applies to other means of communication. Communication, as that definition is defined in these codes, is a conveyance of a debt, such as a fax, telegram, or email, provided that it is irrevocable once sent. The mailbox rule originated in the British case of Adams versus Lindsell, 1818. In that case, the court determined that the buyer accepted the seller's offer to buy wool when they responded to the seller's letter, not when the seller received their reply. So when I walked into your court, again, that did not offer up your service because I didn't receive the service. I saw a notice of your vote. I saw the notation of your vote. I came in as a witness to correct the record and told you specifically, I am not qualified. As a default rule, it does not apply in all cases. Parties can contract around the mailbox rule to change at what time an offer will be considered accepted. And in this case, I'd like to see a financial statement before I accept any offer, Andrea Dreyer. You know, the handwritten statement of intent. Because if you think you're going to get away with posting a bond for $350 with no financial statement of intent, I will create one for $3.5 million. As with most of contract law, the mailbox rule varies from state to state. In a minority of states, such as California, the mailbox rule applies to option contracts. In most states, however, it applies only to bilateral contracts. Again, both you have to be a party to the administration in order to contract either by the option contract or the bilateral contract. You have to be one of those federal, state, or municipal officers or agents whose resident presence is deemed necessary by the board in order to use the post office or the United States Postal Service as registered agents to send your notices back and forth to each other as service agents, public service agents in public trust. In that public trust, you can go ahead and keep contracting with each other, but you are not allowed to contract with myself as I am the benefactor. I am not required to do anything. The next one we're going to talk about, folks, is the selective service system. Again, under the selective service system and how it works video that I posted here quite a while back, maybe a year and a half or so ago. The selective service system, couple elements of that is that a male student at the age of 14 who has the option to drop out of school but continues on is known as a national or community volunteer. He is now considered a volunteer. And upon that volunteer, he is taking upon a high school education known as higher education. And mom and dad are convincing him to continue with that higher education because that covers the medical. So now he's taking upon the benefit of both medical services and medical insurance and the higher education. Again, I went over that in the selective service and what it means and showed sources and everything. In this, it says, when you register with selective service, you're helping ensure a secure future for your community and the United States of America. While there is currently no draft, registration with the selective service system is the most publicly visible program during peacetime that ensures operational readiness in a fair and equitable manner. In a fair and equitable manner. If authorized by the President and Congress, our agency would rapidly provide personnel to the Department of Defense while at the same time providing an alternative service program for conscientious objectors. At the same time, providing an alternative service program for conscientious objectors. Federal law requires nearly all male U.S. citizens and male immigrants 18 through 25 to register with selective service. This is not true, as I've said in the selective service video. Selective service and what it means, we went over the information that qualifies a young man to have to be required to sign up for selective service, and that is to first take upon the benefit of the Medicaid services and higher education. If he does not wish to take upon those benefits, then he is not required to sign up for selective service. There is a procedure. The next one we're going to look at very distinctly, as it relates to that financial index at the local courthouse where they entered the firm name and then the obligor number, which was the social security number with no dashes. And when you look up your social security number, folks, it gives you an instruction to enter in your last name. And then it says social security number, no dashes or spaces. So technically what you're entering in this space as a social security number with no dashes or spaces is in fact the obligor number as shown, material fact evidence on the financial index that I got from the local court clerk showing those conversions of both the last name and the social security number. The next one, as I mentioned, Okay, I think I'm back, folks. Somebody needs to tell me. Yes, Brother Keith needs a new laptop. Somebody, please tell me. Let's see, 904, 904, 903, 902, 901. Yeah. My apologies, folks. Let's see here. Where was I at? Let me see if I pull up some history on this because I lost everything, folks. So, let's see what we got here. Oh, okay. I was going over for U.S. code. Let me look at the other one here, see if I can find it. Well, let's do a lookup on it. 42 U.S. code. What is this one? Corporation. There we go. Okay. Let's see if I can pull these up for you on this one. Oops. There's that one. And that one. Okay, I believe I was around the selective service. I was explaining to the to folks, if you go to look up your selective service number, they're going to tell you to enter in the last name and then the social security number and your birth date or date of birth. And under the social security number, they're going to specifically tell you to enter the social security number without any dashes or spaces. And as I've explained, that occurs with the obligor number that we see on the financial index from the local county courthouse. The next part about it was the selective service. Of course, as I've expressed in the selective service and what it means video on my YouTube channel year and a half ago, it expresses how at 14 years of age, your children are allowed to voluntarily stop going to school. They're no longer required to go to school. So the young male students that continue on because of mom and dad's behest, for the medical services and everything, what they're doing is they're taking upon the benefit of medical and higher education. That's why they call it high school. Okay. And it is only when the male student at this point in time, as a volunteer now, and accepting the medical service and the higher education, is now deemed to be required to sign up for selective service, because he's now receiving those benefits. In exchange, he has to provide benefit for selective service. The Department of Defense, if the nation has to go to war, they will call him up. That's the benefit for the nation in exchange. Now, this is known as National and Community Service under Social Security Administration, under 12 U.S.C. 601, the establishment of a National Service Trust. Under 12.6 or 42 U.S. Code 12651, there's a corporation for national and community service. So like I said earlier, the military departments and everything is for a commercial fiat paperwork. That's all it is. We're not talking about anything but contracts, folks. But in those contracts, operating in those trusts, you have to know your position in that trust. If you go signing up for it, then you're putting yourself as a service agent. And there are certain determinations that need to be made first. You can't just volunteer for that stuff. It has to be deemed necessary by the board for you to be a resident. There's procedure. If that procedure doesn't happen, then it's just not so. It provides an inconsistency. And in correcting those inconsistencies, if you find it becomes an impossibility, then they can't enforce it. Pure and simple. And like I said, I'm going to come back tomorrow with the Universal Postal Union's convention and final protocols in regards to the franking privilege that I mentioned in regards to the Federal Register. You saw that prepaid postage. That's what we're talking about. The benefit of getting a driver's license is so that you can perform commercially in interstate commerce. And we'll be bringing that up in one of our future videos as well. Again, in relations to this and the coming to terms of peace with this administrative system and how they don't have any authority to probate the estate of a person who's in fact alive. A probate means that there's no will. And I am clear evidence of a will. And it doesn't have to be my will. See, as I've said before, I'm just a pass-through. I'm doing my best to fulfill his will, and that is to love my neighbor as myself, owing no man anything but to love each other, for that is to fulfill the law. So anyway, please hit that share, like, and subscribe button. Remember, everybody, to do your own research. Stop believing me. Do not believe me. Do not believe the neighbor. Do not believe the government. Do not believe your mother, for crying out loud. Do your research so you can know. This is the inherent benefit that we have. My people are destroyed for lack of knowledge. So therefore, the benefit is the knowledge. That's your key. That's what brings you life. That's what sustains your life. That's what helps enforce your life. It's the force majeure. So anyway, I want to thank everybody again. Nubs, thanks for coming up on panel. Channel 3, good to see you. Everybody else, God bless. Have a good night. Remember, I care less whether you love me back, but know that I do love you. And this is the only reason I am so blunt. It's not because I don't love you. It's because I love you and I need you to stand up with the right things in order to be able to improve your life and everybody else's lives around you. And granted, sometimes that improvement may not be to your liking because you're so involved in the conveniences. Those conveniences may not be as convenient and beneficial as you might think. Like I said, I've been 7 years without a bank account. So is it a necessity? You can still perform your banking transactions by opening an old bank account and let it operate as a pass-through. No deposits, just a pass-through. Think about this stuff, folks. And again, I remind you, I appreciate everything you do for me. There's some PayPal links down in the details section for anybody that wants to share some love. Please hit that like, share, and subscribe button, and have a good night, folks. Bye now.